Hello, respected viewers. Welcome back to the English Law channel. So this is going to be more about contract law and just going over in fine detail what an offer is. So there's the objective theory of an offer and contract. Smith and Hughes, 1871, is a key case about that. And Lord Clark also looked at this in RTS Flexible Systems Limited against Molkeroi Alles Müller, Gesellschaft mit beschränkter Haftung, and KG, 2010. And this is what Lord Clark had to say in that case. Whether there is a binding contract between the parties, and if so, upon what terms, depends not upon their subjective states of mind, but upon a consideration of what was communicated between them by words of conduct, and whether that leads objectively to a conclusion that they had agreed upon all the terms which they regarded as essential. Close quotation. So the judgment is objective, not what the parties believe, but what would a reasonable man believe if he heard what was said or observed the conduct. So Centro Vincial Estates against Merchant Investors Assurance Company, 1983, is another case about that. In this case, the claimants purchased a commercial building and they let it to the defendants for a rent of about £68,000 per annum, and that was subject to review. Then the claimants accidentally proposed a new rent of £65,000 per annum instead of the £126,000 per annum, which they wished to propose. So the defendants unsurprisingly accepted this mistaken offer. The claimants argued that no reasonable tenant would believe the rent was going to be reduced so much. The defendant said, no, there's a reasonable expectation, bearing in mind they'd communicated their unhappiness with the previous letting. The Court of Appeal said that the defendants' arguments were valid and that there was an arguable case that an offer to let the premises for £65,000 a year was what it said it was. So many other cases have made it clear in business-to-business contracts that interpreting an offer where the offeree is entitled to rely upon what a reasonable businessman in the position the offeree would accept, as in Danani against Krasniansky, 2011. That's a similar case. So bear in mind, there is one situation in which the courts will not go along with the objective approach, and we'll think about the subjective knowledge of the offeree. This is known as snapping at something. The offeree is not allowed to accept an offer which he knows is mistaken. Hartog against Collins and Shields 1939 is a case about that. So the last factor here is that this restricts the disapplication of the normal objective approach. So it's not enough to come up with this exception. The offeree knew that the offerer had made a mistake. The exception is only applicable where the offeree knows that the offeror is mistaken about the terms which he intends to offer. Statoil ASA against Louis Dreyfus Energy Services LP, 2008, is a case about that, known as the Harriet N. The doctrine is applicable where, like in Hartog, the offeree knows that the offeror is mistaken about the terms. Scriven Brothers against Hindley, 1913, is a case of that. Here the offeree should have known that the offeror was mistaken, because in Scriven the offeree caused this mistake due to his own carelessness. So Scriven, against the usual practice, he marked two distinct commodities with the same shipping mark. Okay, now an offer and an invitation to treat are not the same thing. So you make an offer, the idea is that's binding if the other party accepts it. Okay, the Manchester City Council cases, they are leading cases in this instance. In one case the council said we are not going to sell the houses until contractually bound to do so. So Storer against Manchester City Council 1974 is a key case here. The Court of Appeal said that yes, there's a binding contract because they offered to sell him the house. All Mr. Storer had to do was sign it and send back, which he did. And that is in sharp contradistinction to Gibson against Manchester City Council 1979. Here the council sent some correspondence to Gibson and they asked Mr. Gibson if he wished to buy because the council may be prepared to sell. And as Lord Diplock said, the words may be prepared to sell are fatal. All right. So the main difference between the two cases is in Storer there was an agreement about the price. In Gibson there was no agreement about the price, and that's obviously a cardinal term of any contract of sale. So it's key to realise from the word go that not all communications are offers. Sometimes they don't have the necessary intent to be bound upon the acceptance by the offeree. This is just one stage in the process of negotiation. There's a statement of intention. In this case, a party states that he intends to do something. Now, that's not the same as an offerer, saying that he shall do something. Harris against Nickerson, 1873, is an example of that. The auctioneer advertised something. It was a statement that he planned to sell on particular terms. It was not an offer that he would sell, definitely sell on those terms. Supply of information is different again. You might supply information to inform a party. So the statement is not intended to be acted upon. There's Harvey against Fassy. Here, one party sent a message, a telegram, responding to a question by another. What's the lowest price you would accept for this property? Now, this did not guarantee that the party would sell for that lowest price. So the lowest that he might accept. He was not bound to accept that lowest price. An invitation to treat is different. Now, this perplexes many people. So, displaying goods, that's an invitation to treat. Pharmaceutical Society against Boots, 1953. Boots is a pharmacy in the United Kingdom. Might not know that. No, they don't sell boots, despite the name. Presumably it was a Mr. Boot started up, but there's no apostrophe in Boots. Anyhow, so there's Fisher against Bell, 1961. Now, if something's displayed on a machine, that is usually an offer, as in Thornton against Shoe Lane Parking, 1971. So Shoe Lane is in London, very close to St Paul's Cathedral. So Goldman Sachs got one of their offices right there. So somebody parking his car, and there's no human to negotiate. That's it. You can't say, could you reduce this or change the terms? The machine can't change the terms. And there are other cases like this, Partridge against Crittenden, 1968. Here, they advertised a bilateral contract. You may have heard of Carlisle against Carbolic Smoke Corp Company, 1893. So a unilateral contract was there when the advertisement made an offer. So what's the difference between unilateral and bilateral contracts? So there are consumer protection rules which forbid misleading or false advertising. The Unfair Trading Regulations, 2008, it forbids misleading adverts which are intended to gull consumers. The Court of Justice of the European Union said it would be a breach of consumer protection law if in a shop a consumer was not sold things under the advertised terms. That's per Trento Sviluppo Società con responsabilità limitata against Autorità Garantate della Concorrenza e del Mercato, 2014. Obviously an Italian case, it's European Union law. So Trent's the region. And it was the latter organisation, the authority to guarantee market rules adherence. So you can also have a request for tenders. So saying, well, what will you offer? This is Harvella Investments Limited against Royal Trust Company of Canada, Limited, 1985. So an invitation to treat often has the implied term that all tenders shall be considered, right? Not that they'll be accepted. Blackpool and Field Aero Club Limited against Blackpool Borough Council, 1990 is a case about that. So in an auction, a bid is an offer. And when the auctioneer has the hammer fall, that means he's accepted the offer. So auctions may have a reserve price, in which case there's a collateral contract. So the auctioneer has to accept the highest bid. Waller against Harrison, 1859 is a case about that, or Barry against Davies, 2000. So we'll look briefly now at the communication of an offer. So for an offer to take effect, it must be communicated. You can't accept the offer if you didn't know about it. Why is this? Because the whole thing is about agreement. You can't agree with things if you don't know about them. So that's why I talk about a meeting of minds, consensus ad idem. Okay, so there has to be a mirror, one offer, and it's mirrored by the acceptance. So how do you need to communicate this? Well, in Gibbons and Proctor, 1891, a policeman was able to get a reward for something, even though they didn't know a reward had even been offered. That which seems to go against the doctrine of communication. There's the Australian case R against Clark, 1927, in which the judge held there cannot be assent without knowledge of an offer, and ignorance of an offer is the same thing, whether it's due to never hearing of it or forgetting about it after hearing. Close quotation. There was Tin against Hoffman, 1873, and this deals with this thorny matter of cross offers. two offers to each other. Anyway, so then you have to accept the offer. So how can an offer be accepted? Well, agreeing to the terms of the contract, often signing a document. Expressing your thankfulness for instructions, that's not acceptance. That was found in Arcados Consulting against AMC, 2016. It's not. We've got to make it clear we are accepting it. Ravalet Independent LLC against Anatech International UK. In this case, it was a draft agreement, and it was accepted by behaviour afterwards, and that showed that the party had accepted the terms, even though the draft said the agreement would only be binding if it was signed. So contractual acceptance is established objectively, just like a contractual offer. So acceptance occurs when the offeree's words or behaviour make someone objectively believe that there was agreement there. So Brogdon against Metropolitan Railway Company, 1877, the offeree accepted performance or Claxon Engineering Services Limited against TXM, Olaj ES Gaz Kutato KFT, 2010. Is a Hungarian company carried on doing business with its English analogue after the English one spurned the proposal for arbitration in Hungary of any disputes. Anyway, that was still thought to be an acceptance under English law. So therefore, the arbitration would be under England's jurisdiction. So if an offeree suggests new terms, this is a countered offer, and that destroys the original offer. So a counter offer is not an acceptance. Okay. Anyway, Hyde and Wrench, 1840 is a case about that one. So if the offeree asks a question, that's neither an acceptance nor a rejection. It's merely just that, a question. That's Stevenson, Jakes and Company against McLean, 1880. So in Butler Machine Tool against Excel in 1979, they decided that the last shot wins the so-called Battle of the Forms, though Lord Denning, who was Master of the Rolls at the time, said he doesn't like this all or nothing approach. He said, well, let's look at the entirety of the correspondence and see if there's been a real agreement or not. The agreements might be reconcilable. Anyway, this has not been followed in other cases. Tech Data Interconnections Limited against Amphenol Limited, 2009 is a case where the Court of Appeal went by the usual approach of saying we have to be certain here, especially if it's a business contract. And who's going to pay for the benefits received, what are the benefits going to be received, and so on. So there's a law of restitution which says that a recipient has the benefit of this obligation to pay something to a party who conferred a benefit, even if the contract comes into existence between the two parties, like BSC against Cleveland Steel, 1984. So some courts have said that some relationships are not contractual. There's the Euromedon, 1975. Lord Wilberforce said, having committed itself to a rather technical and schematic doctrine of contract, takes a practical approach, often at the cost of forcing facts to fit uneasily into marked slots of offer and acceptance. So that was a famous shipping case about privity. So as another analysis, sometimes the traditional analysis has just been rejected. President of the Methodist Conference against Preston, in this case, the Supreme Court said the way that a Methodist minister was offered a job, well, that was not something which could be an instance of contractual formation. Okay, so that's enough for the moment on contract. Toodaloo.